How would you like it if $1 million ended up going to your ex-wife? Hi, Jeff Marsacci, the Plain English Attorney, and welcome to the video. Today we are going to talk about 5 divorce disasters and how this can be negatively impacting your estate plan and your future. And let's go ahead and jump right into it, because we have a lot of people out there who end up getting through this emotional divorce. They end up having to separate from their spouse, look at their assets, and they just want to get away. They just want to get it done. And so when the court gives them this decree, yes, you're divorced, it's like, okay, now I can breathe a sigh of relief. And often there's a whole lot of other details afterwards with their planning that they're just not getting around to, and it could be a huge disaster down the road. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. So let's talk about the first thing. The very first disaster is not planning ahead of the marriage in the first place. And I'm not just talking about a premarital agreement. I'm talking about arranging all of your finances. And most importantly, in putting together that premarital agreement, you are going to talk about here's how the marriage is going to work. These are discussions that people should have long before they ever get married in the first place. How are we handling finances during the marriage? What are we going to do about kids? Is everybody still going to continue to work full-time if there are children? Who's paying for what in the relationship? Is there a certain percentage? And then keeping up with it. Now, I go through an awful lot of that in my book, The Divorce Firewall Strategy. It's available on Amazon. We'll go ahead and put a link in the description to get that book. So this is planning before marriage. But if you don't have that in place, when you end up with a divorce, it's wide open. It's kind of the same thing with estate planning. If you don't put together any kind of will or trust or any kind of plan, well, okay, the state has a plan for you and you are not necessarily going to like those terms. But it's too late at that point. So if you do not have a premarital agreement where you've agreed with that future spouse, here's how everything is going to run in the marriage. And incidentally, as part of this marriage strategic plan, what if it breaks up? Here's how that will work. So many people just put this stigma on a premarital agreement. You don't trust me. Oh my gosh, you're dooming the marriage to failure by even addressing this. No. Look, all a premarital agreement is a strategic plan for the marriage, which will also include here's how we're agreeing we're going to get out of it if it doesn't work, because nothing in life is certain. So you might as well have that written plan. So that's the first disaster. What is the second disaster? The second disaster is trying to do the divorce yourself and not actually getting an attorney. So let me go ahead and talk about this. In North Carolina, you can go ahead and just go down to the courthouse or download paperwork, and it'll walk you through, here's how you get divorced, and you file the paperwork after a year of separation, and okay, you go to court, you have your date, judge asks a couple of questions, all right, done, boom. Oh, wow, wasn't that easy? Isn't that great? Yeah, but it did absolutely nothing to divide up your property. Nothing. So this is going back probably about 15 years, if not more. When someone came in, he wanted to do his estate planning. He wanted to make sure that everything was going to go where he wanted it to go. He didn't have any children at that point, but he did have a niece and nephew that he wanted everything to go to, and he wanted it done the right way. And he handed over the deed to his house, and I'm like, wait a minute, who's this person on here? Oh, that's my ex. Okay, so why is her name still on the deed? Well, we divorced, so it's fine. It's mine. I've been paying all the money. He had moved in with her into the house, and only like 4 or 5 months later, she left, and said, this isn't working. And they eventually got that do-it-yourself divorce. He had been paying for about 15 years. I think it was closer to 17 years. And he's like, I want to go ahead and pay this off and just be stable. She's entitled to half that house. And if you die, it goes to her automatically. Well, what can we do to stop that? Well, okay, you need to go and get her to sign over her rights and have her acknowledge that she doesn't have any kind of monetary claim on this. We were divorced 56 years ago and blah, blah, blah. Look, it doesn't matter. That's the titling. So having this do-it-yourself divorce cuts off all of that other stuff that we need to handle in a divorce with all of the property stuff. So again, the second disaster is just trying to do it yourself because there are a lot of details that an attorney who understands family law is going to end up taking care of for you so that it's all kind of laid out. But not fully. Not fully, and not all attorneys will do it exactly the same way. So that's going to end up bringing us to the third big disaster, and it's not executing on all of these little changes that you agreed to during the divorce process. If you don't change your beneficiary designations, if you don't actually split up the house, if you don't actually pay off the equity to the spouse, if you're keeping the house or vice versa, then you are not actually separating that property, and it could become a disaster. Now, I'm going to tell you a story. This was a life insurance agent that I know, and the story's going back several years, but I'm sure it just happens. Look, people end up getting divorced from their first spouse. He says it happens every year, at least one or two, if not more, where a client dies, the widow calls up and starts saying, we need that life insurance. And they go and they check the beneficiary designations. And the ex-wife is the person who's listed as the beneficiary. He got divorced 10 years ago and we got married and I can't, what are you talking about? This needs to be coming to me. No, the contract says who the beneficiary is. They got divorced. Yeah, and he was allowed to make all of these changes. And I'm sure the divorce attorney probably encouraged him, look, go to your agent, change these beneficiary designations, go to the bank, take off these beneficiary designations, make sure you actually are splitting up the bank accounts, go ahead and execute that. And to be fair, the attorneys aren't just usually just pawning it off on them and saying, go and do it yourself because I'm not going to do it. It's, well, okay, you can do this, or you can pay me my $350, $400, $500 an hour to do it for you. Oh, no, I'll do it. And then they don't. This same agent, and this is a pretty standard practice, every year or so, they'll send out a letter. Hey, time to come in and review your plan. Make sure everything's good. And they just ignore it. So when those widows are complaining, you never change that. Look, yeah, he got divorced 10 years ago. There's 10 letters that went out saying, come in, let's review everything. And he never did. So how would you like it if $1 million ended up going to your ex-wife after you pass on, as opposed to the person you're married to now? Why would you do that? You wouldn't want to, but that's the big disaster. All right, so the fourth big disaster, not changing your healthcare documents, meaning your healthcare power of attorney, nomination of conservator of the person, and leaving your spouse on there. Now, this is going to vary by state and jurisdiction. There's an awful lot of failure to plan, and so the state kicks in some default mechanisms, and some states have this. In fact, it wouldn't surprise me if most states have something like this. If you don't ever change your will, if you divorce someone, then they are automatically removed as a beneficiary of your will. And in a lot of cases, it would also be, okay, we're removing them as that first executor. We're just going to treat them as if they had died before you. All right, so that's a default that protects in that particular document. But that may not necessarily apply to things like who is your healthcare power of attorney. So you need to make sure, one, that you are redoing your entire plan, but that healthcare decisions, that you are not putting an ex-spouse or even an almost ex-spouse in the position of being in charge of your health. Let's go ahead and talk about a nightmare scenario, and then I'll talk about a real life one. The nightmare scenario, you were in the middle of a divorce. You still have to wait 5 months. You got a separation agreement, and it's laying out all of the division of the property and the different rights so that that's all taken care of. It's just, okay, it becomes a court decree by the time you get to that official divorce. You still got several months left before the official divorce is final. And then you end up having a heart attack, or you're in a coma and you're in the hospital. And if you don't have a healthcare power of attorney, your spouse is still first in line. So they'll be coming in and making these decisions. It's my husband. It's my wife. They're the ones making all of these healthcare decisions because you didn't put it in writing. You didn't have the proper healthcare power of attorney put in place. So now they're in charge of you. What happens if you die before the divorce is final? They could stand to inherit everything. So this person that you're divorcing could inherit everything, and you have put your life into their hands. Why would you do that? You don't want to do that. You want to make sure that you've got a good healthcare power of attorney that names the people you want making these health decisions, not the person you're divorcing. So that's a huge disaster. Now, the real life scenario, this actually happened with a relative. She had been divorced from her husband for many, many years. She has 3 kids. They were all adults, but the youngest was, I don't want to say barely an adult, but was definitely a young adult. And then she ended up slipping into unconsciousness and in a coma because of a health thing. I'm not going to give too many details on that. But she couldn't make the decisions. She didn't have a health care power of attorney. The youngest daughter came in. It's like, I got to take care of my mom. I don't know what to do. I'm going to call dad. She called the ex-husband in, and he was basically the person calling all the shots on her healthcare decisions because the daughter didn't know what to do. So the daughter signed off on everything that dad said. Now, thankfully, this actually worked out okay. There wasn't such a huge animosity that it was going to really affect the decisions that were being made, and the best decisions were made at the time. But wouldn't it have been so much easier if you had listed the responsible adults who would make these decisions independently, listed in a healthcare power of attorney, and then years down the road when that youngest adult child was more capable, that they would end up in that document. So those healthcare documents can be a really, really big deal. All right, let's go to the next one, the last one, and the most important one. The 5th big divorce disaster potential is not redoing your estate planning documents, including your will and your trust. Now, I already mentioned that if it's a last will and testament, okay, that's fine. Your spouse ends up, depending on your state law, being automatically kind of taken out. But look, that whole scenario ends up becoming something that you may not necessarily want, because if it drops to the next executor and they're the ones who end up being the trustee and the kids are still young, the money going to the kids may now end up having to have court supervision through the will. What if it's a revocable living trust? Okay, again, dependent on state law. It very likely will also impact the trust as the beneficiary, but it's the same issue. If the money's going to the kids, the ex-spouse may be the full guardian, and now it's like, okay, you need to give me the money for these young kids. If your trust is updated to very clearly say, here's exactly what we want to have happen with the money, and the trustee's the one in charge and they have full discretion, then we're not having to deal with a spouse actually receiving money when the trustee can simply pay bills directly. So if you don't redo your will and the other pieces of your estate plan, you're just leaving it open to a disaster. Now, and this is the other thing that I end up seeing. What if that second person in line was your spouse's brother or sister? Do you still want them to be in charge of the money? Or would you prefer people from your quote side of the family, your friends, the people you choose? When couples come together to do their estate planning, there's often a little bit of a compromise. Okay, we'll put your brother first if my sister's second. And they're kind of mixing in the people who are in charge of anything related to finances through the will or the trust, who's in charge of things, because they're looking at it as a group family. These are the people we trust. Once that divorce happens, there's a lot of division and people tend to stick with their sides of the family. You need to update all of that stuff. The other thing is there may have been some decisions that you kind of looked at and compromised, or you went and you said, okay, fine, if this is really, really what you want, but it's not what I want, I would do it differently. You need to make sure that's incorporated and updated into your plan. Now, here's one thing that ends up not really being that negotiable, and it's the actual guardianship. Okay, look, if you end up with kind of joint custody, parents have a constitutional right to be able to raise their children, and it takes a bit to overcome that. So even if you have full custody, naming another guardian may not end up influencing the court. They may still have guardianship go to the other parent. In fact, it's very likely. It's a big hurdle to overcome. But that doesn't mean that you can't secure the money so that you can put the people you want in charge of making decisions on the money. So make sure that you are avoiding that fifth disaster by, even before you're getting that divorce, you're setting things up the way you want them to. Now, one way to make sure that it's all kind of going exactly the way you want during life, if the marriage is okay or if the marriage falls apart. And I talk a lot about this in my book, The Divorce Firewall Strategy, where you can set up your own assets to make sure it's going exactly where you want it to go. And it may be that you're not incorporating the spouse into your separate estate plan that's going to benefit the kids using a domestic asset protection trust. But you could also include the spouse in some other types of planning, but it's going to secure most of your assets, so it's completely outside that divorce. Now, you can also check out that book at divorcefirewall.com. And pretty soon we're going to be working on putting together a whole kind of course program on how this system works the right way. And we'll put that out to you at the right time. So I hope you found that information useful. As I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.